Did the cops lie to protect their own? That's what the Karen Read trial forced a jury and the country to ask. I'm Ronald W. Chapman, federal criminal defense attorney, Marine Corps veteran. I see plenty of hatchet jobs in the justice system day in and day out, but few as crazy as the Karen Read case. Over the next few minutes, I'm going to show you how the Karen Read case went from accused cop killer to acquitted defendant over the course of 2 trials. Very rare, acquitted on retrial. We'll break down the 5 moves that flipped this case from a potential prosecution victory into a defense victory. We've got a shattered taillight, a detective's crude text messages regarding Karen Read, and why every defense attorney should take notes on this, every defendant as well. Fourth Amendment, let's start with the basics. The forensic fortress that the government had was built on sand. The state had a straight line story. Read reversed her Lexus at 24 miles per hour into her boyfriend, Boston officer John O'Keefe. 24 miles an hour. Taillight shards matched her car. One shard had his DNA on it. The medical examiner said trauma and hypothermia caused the death. Open and shut, not so fast. Sure, there was a 24-mile-an-hour reversal, and sure, there was DNA on the shards, but how did they get them there, and who put them there? The defense brought in their own experts who said the damage to the SUV was inconsistent with hitting a human. Funny enough, those experts weren't originally retained by the defense. They were retained by an outside entity. The defense also pointed to dog bites on O'Keefe's arm. And the kicker? A snowplow driver said the yard that the body was found in was empty at 3 o'clock in the morning, after the state's timeline for the death had occurred. So when did the body get there? Who really put it there? That's where we get into some of the conspiracy theories in the case. The second thing that happened here is the experts were turned into effectively static in this case. Modern juries expect science. We call it the CSI effect in a trial. But the defense didn't just counter the state's experts, they absolutely dismantled them. One prosecution expert had a fake degree on his resume. An FBI contractor said the car strike wasn't supported by the evidence. One government expert painted himself in blue but didn't match the accident at all in any way, shape, or form, and just simply hit himself repeatedly with a vehicle. Didn't make any sense to anybody. I've got a Substack article about that as well. By the end, the jurors weren't listening to science. They were drowning in it. But they were drowning in it from both sides, and complexity definitely favors reasonable doubt here. When experts cancel each other out, jurors go back to their gut. How do they feel about the case? And that's exactly where Karen Read's defense team wants them. That's where reasonable doubt lives. That's where questions can arise. The third thing that I really want to talk about is framing the investigators and not just the crime. I've often said that in order to get an acquittal, you can't just win the case. You need to embarrass the prosecution for having brought it in the first place, and there's no better way to do that than to show misconduct. Bad cop equals bad case. They did it in the O.J. Simpson case with Mark Furman. They did it in the Rittenhouse case with some of the investigators there. Bias is on trial, and it's very important. Trooper Michael Proctor, the lead investigator in this case, who was later fired by the department after the original mistrial, sent texts hoping Read would off herself. Yeah, you heard that right. On the record, in court, texts were read related to that. Also, very crude jokes. Of course, he was later fired when this came out. But when the defense implied that evidence had been planted, that dart was able to sink into a very bad Proctor who was dismissed, who even the department didn't want to believe in. Jurors were ready to believe that Karen Read could have been framed. If the guy leading that case is so unprofessional, how can you trust anything that followed? Number 4, you need to offer an alternate universe. The judge wouldn't let the defense point fingers at specific party guests. That didn't matter. The defense floated enough. There was a German Shepherd with possible dog bites on O'Keefe. A German Shepherd was at the house that he was found in front of. A shady 2 a.m. Google search by one of the people involved in the case, a relative of O'Keefe, how long to die in the cold. Other cops in the house with unclear timelines were potentially suspects in some wrongdoing. And it didn't need to be a perfect theory. It just needed to be plausible, because the defense can also say that the cops didn't do a very good job of investigating their own. That's the bar for reasonable doubt. Number 5, the defense humanized the defendant through action. When everyone else at that house was silent, Karen Reed was the one out at dawn looking for O'Keefe. She called 911. She cried in the snow. That's not what a killer looks like, and the defense didn't even need to say it. The jury saw it from themselves, and they heard it on the phone messages that she left for O'Keefe, not knowing that at the time he was deceased. You got to give a jury a way out. The OUI Offramp is the way that the defense here gave them an out. If they convicted on the OUI, it's not murder. It's something that she can overcome. The judge gave her probation for that. And that's the off-ramp for those jurors that may want to convict on something, but don't feel comfortable giving her the entire murder, or maybe have reasonable doubt. At least they can walk away and, as we say, split the baby there. The prosecution overreached in this case. The defense gave jurors an off-ramp. They didn't fight the OUI charge, so the jury could say she was drunk, maybe reckless, but not a murderer. That lended a lot of credibility to the defense in this case, and they didn't stretch and strain just to acquit her of all charges and reach too far. They effectively conceded that charge, and they knew that would be the outcome. That was a very important and vital defense move. Let's hit some takeaways here. Forensic certainty is fragile when probed properly by defense counsel. You discredit one cop and the entire case goes down, just like we saw with O.J. Simpson, just like we saw with Proctor here. Competing experts cancel each other out. That's exactly what the defense did, and maybe they even made a few points on their own experts. Subtle alternative theories can fracture a timeline, and that's very important. And then the jurors crave the middle ground. Give it to them. Give them the respect of letting them figure out the case, and give them the tools to do so. If you found this breakdown helpful, hit like, drop a comment, subscribe to either my YouTube or my Substack. Head to ronaldwchapman.com for more deep dives into cases and how you might be able to achieve acquittal in yours. My Substack has the full article with footnotes, including some of the evidence in the case. And if you're serious about understanding how trials are won or lost, check out my books, Truth and Persuasion and Fight the Feds, both available on Amazon through a link on this website or in the Substack article. Thank you so much for joining me. Stay sharp, stay free. And this video is for educational purposes. If anybody considers this to be legal advice about your particular case, you may want to go see a different type of person, probably a doctor, and get yourself checked out. As always, stay free, stay safe.